They terminated my employment at 4:23 p.m. on a Thursday afternoon for what Diane Fletcher called persistent attitude issues. Not performance deficiencies, not policy violations, not misconduct of any measurable kind. Attitude issues. I had dedicated 17 years to Titan Strategic Solutions, beginning as an entry-level data analyst and ascending to Executive Director of Client Relations, securing 4 National Excellence Awards, generating $9.2 million in new business partnerships during the previous fiscal year alone. Yet according to corporate leadership, my attitude required immediate correction through termination. The meeting lasted exactly 11 minutes. Diane sat rigidly behind her glass desk with Carlos Hammond from Human Resources positioned beside her, tablet ready to record every word of the proceedings. "We're ending your employment relationship effective immediately," Diane announced, her tone carrying all the warmth of automated phone systems. "You'll execute these separation documents and surrender all company assets before departing the premises today." She pushed a manila folder toward me across the polished surface. Inside were 7 distinct documents, each representing what they believed would be my quiet acceptance of dismissal. Termination notification form, final compensation acknowledgement, company property return checklist, confidentiality agreement, restrictive covenant preventing competitive employment, standard liability waiver, and the comprehensive release, that particular document where I would supposedly relinquish all legal claims against Titan Strategic Solutions in exchange for precisely nothing beyond my earned wages. I examined each page with deliberate attention to detail. Carlos shifted his position 3 times during my review. Diane checked her phone twice, clearly expecting this process to conclude rapidly. They wanted me processed and removed before the executive floor cleared for the evening, before I could speak with other department heads about what was actually transpiring behind closed doors. What neither of them understood was that I had been methodically preparing for exactly this scenario for 11 weeks. Ever since Jordan Ellis assumed the Chief Executive Officer position and immediately declared that anyone beyond 42 years old represented obsolete overhead requiring elimination. Ever since he began recruiting 26-year-olds fresh from graduate programs who would accept half my compensation and work double my hours without questioning his questionable strategic vision. Ever since I overheard him telling Diane during a budget meeting that my salary could be better allocated toward 5 junior associates who wouldn't challenge his authority or contradict his flawed market analyses. So I took action. Invested $11,500 consulting with employment attorney named Helena Winters who specialized exclusively in wrongful termination litigation. Together we conducted exhaustive review of my employment agreement from 2017 when I had been promoted to Executive Director of Client Relations. That contract contained very specific provisions, protections I had negotiated when Titan had been desperate to retain me after I received an offer from their primary competitor promising 35% higher compensation. Protections they had completely forgotten existed. Protections that were approximately 7 minutes away from costing them substantially more than my annual salary package. I signed the first document without hesitation. Termination notification acknowledging my employment concluded today. Signed the second form confirming my final paycheck would be processed according to standard payroll schedule. Signed the third document listing company property to be returned, including laptop computer, mobile phone, building access credentials and client database access codes. Then I reached the confidentiality agreement, the standard non-disclosure document preventing me from discussing proprietary business information or client relationships. Except this particular agreement was no longer standard. Not after the modifications I had implemented 6 months earlier. During a routine contract review initiative, Human Resources had distributed updated confidentiality agreements to all executive staff. Standard procedure, they assured everyone. Simply modernizing language to reflect current regulatory standards. Sign and return within 3 weeks. Most executives signed immediately without detailed examination. I did not. I brought that confidentiality agreement to Helena Winters, had her analyze it comprehensively, and discovered 6 ambiguous provisions that could be interpreted multiple ways under state employment statutes. So I made subtle modifications. Nothing overtly obvious, just minor adjustments to section designations, supplementary language in footnotes, cross-references to my employment contract that human resources wouldn't detect unless they conducted word-by-word comparison with legal counsel present. Then I submitted my signed version. Human resources filed it without scrutiny. Why would they examine it carefully? I was an executive director, not an attorney. They assumed I had signed exactly what they distributed. They never verified that the document I returned was identical to what they had sent. That represented their first critical mistake. Their second mistake was terminating my employment without documented justification. Their third mistake was about to become extraordinarily expensive. I signed the confidentiality agreement, the modified version that had been residing in my personnel file for 6 months. Then I proceeded to the comprehensive release, the document where I supposedly waived all legal claims. Except I had added one carefully crafted sentence in the signature section. Small typeface. Page 5, subsection 3. Easily overlooked if you weren't specifically searching for it. Upon involuntary termination without documented justification per company policy, employee signature on this agreement constitutes acceptance of separation compensation outlined in Employment Agreement dated April 19, 2017, Addendum F, Sections 4 through 9. Nobody read it. Not Carlos, not Diane. They simply observed me sign and exhaled with relief that I wasn't creating difficulties or demanding explanations. I returned the folder to Carlos, placed my laptop, phone and building access card on Diane's desk, stood and shook both their hands professionally. "Thank you for the opportunity," I said with complete composure. "This has been educational." Then I departed Titan Strategic Solutions at 4:34 p.m. with my professional dignity intact and a legal mechanism activated that they would discover in approximately 4 hours. The drive home required 42 minutes through rush hour congestion. I didn't experience frustration. I had nowhere urgent to be. No client meetings to attend, no project deadlines to satisfy. For the first time in 17 years, my evening existed completely free of professional obligations. I stopped at a specialty market and purchased ingredients for an actual home-cooked meal instead of my typical restaurant takeout. When I arrived home, I began preparing dinner properly. My husband Samuel arrived at 6:45, surprised to find me in our kitchen making roasted chicken with herb vegetables from scratch. "You're home unusually early," he observed, setting down his briefcase. "I was terminated today," I told him while checking the oven temperature. "For attitude issues." He froze in the doorway, expression shifting from confusion to concern. "Are you all right?" "I'm exceptional," I replied, adjusting the seasoning. "Just wait. This situation improves dramatically." We were midway through dinner when my phone rang. Unknown caller identification. I answered on the 4th ring. "Isabella Rhodes," a man's voice said, tension evident in every syllable. "This is Douglas Pemberton, General Counsel for Titan Strategic Solutions." My hand tightened slightly around my wine glass. "Precisely on schedule." "Ms. Rhodes," he continued, words coming quickly, "I need to discuss the documents you executed today." "The termination documents?" I replied, maintaining neutral tone. "What about them?" Silence. Papers rustling in the background. "There's specific language in the signature section on page 5, subsection 3 of the comprehensive release," he said, voice strained. "Did you review that language before signing?" "I reviewed every single page," I said calmly. "That's why I signed." The silence that followed was profound. I could hear his breathing but no words emerged. Then, in a voice much smaller than one would expect from a company's chief legal officer, he said, "Please tell me you haven't signed the confidentiality agreement yet." "I signed everything Human Resources provided," I responded. "All termination documents. Complete package." His voice cracked slightly. "Everything? All documents?" "Yes, all documents," I confirmed. "Why? Is there a problem?" Another pause, longer this time. More rustling. Someone else speaking urgently in the background. Then Pemberton returned, his voice now carrying a tremor. "Ms. Rhodes, I need you to read me the exact language from the signature section of the comprehensive release you signed." I retrieved the photograph I had taken of the document before signing, though I had memorized every word. "Upon involuntary termination without documented justification per company policy, Employee signature on this agreement constitutes acceptance of separation compensation outlined in employment agreement dated April 19, 2017. Addendum F, Sections 4 through 9. I read slowly and clearly. The silence was deafening. Actually physically deafening. I could hear him breathing but no words came. Finally he spoke, voice barely above a whisper. And what does Addendum F specify? Minimum 3 years base compensation plus all accrued benefits, immediate vesting of all stock allocations and performance incentive payments as specified in original agreement terms, I replied evenly. Upon involuntary termination without documented justification. More silence. Then I heard him speaking to someone else, voice muffled like he covered the receiver. She embedded it in the release. Yes, the entire separation package. I don't know how this wasn't caught. When he returned to the line, his voice was carefully controlled, the kind of control that comes from barely contained panic. Ms. Rhodes, there appears to be some confusion regarding the documents. We'd like to arrange a meeting to discuss this situation. No confusion on my end, I said pleasantly. I signed exactly what your Human Resources Department provided. The confidentiality agreement I returned during the contract review initiative 6 months ago. The comprehensive release from your standard termination package. Everything properly executed and accepted by Titan Strategic Solutions. Pemberton attempted a different approach. The confidentiality agreement you signed isn't the version we distributed. That's accurate, I said. It's the version I submitted and your Human Resources Department accepted, making it part of my official employment file. That's my controlling confidentiality agreement under state contract law. Your acceptance of my signed version constitutes agreement to those modifications. Ms. Rhodes, Pemberton said, his voice rising, losing that careful control. Employees don't get to modify company documents unilaterally. They do when employers accept those modifications without review, I replied. You had 6 months to reject my confidentiality agreement. You didn't. You filed it officially. You treated it as valid. Now it's binding. I need to consult with our employment litigation team and call you back, he said quickly. Feel free, I said. My attorney, Helena Winters, will be managing all subsequent communications. She specializes in employment law. Tell Jordan Ellis to have his team contact Ms. Winters directly. I disconnected the call. Samuel stared at me across the dinner table, fork suspended in midair. The company's lawyer just called you, he said slowly. Their general counsel, I corrected, taking another sip of wine. Sounds like he just discovered they owe me approximately $680,000. Possibly more depending on stock allocation valuation. His eyes widened considerably. How is that even possible? Because my employment agreement from 2017 contains a separation package provision they forgot existed, I explained. And when they terminated me without documented justification, they triggered it. But the elegant part is the release I signed includes language accepting that separation package. So by their own documentation they acknowledge they owe it to me. His expression shifted from shock to something resembling admiration. That's brilliant. That's absolutely brilliant. That's strategic planning, I corrected. I've been preparing this for 11 weeks. Before I explain exactly how this legal mechanism functioned, if you're enjoying this story about hidden contractual provisions destroying corporate arrogance, hit that subscribe button right now because we post stories about workplace justice regularly. You won't want to miss what happens next. My phone rang again 33 minutes later. Different number. Isabella Rhodes, Helena Winters said, her voice carrying barely suppressed excitement. I just received a very interesting voicemail from Titan's general counsel, Douglas Pemberton. Apparently they've discovered the modifications you made to the confidentiality agreement and the cross-reference in the comprehensive release. They're in complete panic mode. Excellent, I said. That was the plan. She laughed, actually laughed. Isabella, this is the most elegant legal trap I've witnessed in 19 years of employment law practice. You embedded the separation package acceptance in documents they believed were protecting them. Now they can't argue you didn't agree to termination terms without simultaneously acknowledging those terms include paying you $680,000. It's beautiful. When do we meet with them? I asked. Tomorrow at 3 p.m. if you're available, she said. I cleared my afternoon schedule the moment Pemberton called. I'm available, I replied. Let's collect what they owe me. Perfect, Helena said. I'll send Pemberton a formal demand letter tonight outlining our position. Employment agreement dated April 19, 2017 remains valid and controlling. Addendum F specifies separation package terms. Your signature on the comprehensive release constitutes acceptance of those terms based on the language you added. They are contractually obligated to pay. If they refuse, we file for breach of contract and add wrongful termination, age discrimination, and breach of good faith dealing to the claims. Estimated jury verdict range would be $1.1 million to $1.8 million. They'll settle. They have no choice. The meeting occurred at Helena Winter's office in the financial district. Neutral territory. Douglas Pemberton arrived with 3 associates, all appearing like they spent the night reviewing documents and realizing exactly how catastrophically they had failed. Diane Fletcher came looking decidedly uncomfortable. Carlos Hammond from Human Resources sat in the corner taking notes, appearing like he wanted to be literally anywhere else. Nobody looked pleased with the situation. Pemberton was perhaps 51, expensive suit, the bearing of someone accustomed to winning legal arguments. But today he looked stressed, exhausted, like he'd aged 7 years overnight. Ms. Rhodes, Pemberton began, setting his briefcase on the conference table. We've reviewed the documents you signed yesterday. There appear to be significant discrepancies between what we provided and what you executed. No discrepancies, Helena said smoothly, opening her own folder. My client signed exactly what your Human Resources Department gave her. The confidentiality agreement she signed is the one she submitted during your contract review initiative 6 months ago. The comprehensive release is the standard form from your termination package. We have copies of everything if you'd like to review them. Pemberton pulled out his own folder, the movement sharp and precise. The confidentiality agreement Isabella signed is not the version we distributed in June. It contains additional language and modified section references. That's correct, Helena replied calmly. The confidentiality agreement Isabella submitted during the review cycle contained modifications. Your Human Resources Department accepted it, filed it in her personnel folder, made it the controlling confidentiality agreement, made it the operative agreement governing her confidentiality obligations. If you had issues with the terms, you should have rejected her signature and required her to sign your version. You didn't. Under state contract law, acceptance of a modified document constitutes agreement to those modifications. That's not how corporate document procedures work, Pemberton said, his voice rising. We distribute a standard form. Employees don't get to change it unilaterally. They do when the employer accepts the changes, Helena said, her tone still pleasant but increasingly firm. Look at your own process. You sent confidentiality agreements to executive staff, asked them to sign and return within 3 weeks. Isabella returned a signed document within that time frame. Your Human Resources Department accepted it without comparison to the original, filed it officially, treated it as valid for 6 months. You can't retroactively claim it's invalid because you didn't read it carefully. That's negligent document management, not fraudulent modification. Pemberton turned to Diane, his expression hard. Did you review her confidentiality agreement when she submitted it? Diane looked miserable, her face pale. No, she admitted quietly. We assumed executives would sign what we sent them. We didn't compare returned documents to originals. We just filed them. Helena smiled slightly, just a hint at the corners of her mouth. That's your problem, not Isabella's. Your inadequate administrative process created a valid, binding agreement with terms you didn't intend but nevertheless accepted. Now let's discuss the comprehensive release. Pemberton pulled out another document, this one with yellow highlighting marking the relevant passage. The release clearly states that Ms. Rhodes waives all claims against Titan Strategic Solutions. It does, Helena agreed. It also clearly states in the signature section on page 5, subsection 3, that signing constitutes acceptance of the separation package outlined in her April 2017 employment agreement. You can't have it both ways, Mr. Pemberton. Either the entire document is valid, including the separation package acceptance, or the entire document is invalid, including the waiver of claims. Choose carefully. What separation package? Diane asked, looking genuinely confused. We never offered her severance. You didn't offer it voluntarily, Helena said. But her employment agreement requires it. She pulled out a thick document tabbed and highlighted. April 19, 2017. Executive Director of Client Relations Employment Agreement between Isabella Rhodes and Titan Strategic Solutions. I'm certain you have this in your files. Turn to Addendum F, Sections 4 through 9. Separation Package Provisions. Pemberton flipped pages, his jaw tightening with each one. He read silently. His face progressed from confused to appalled to tight-jawed in approximately 50 seconds. This contract is 7 years old, he said finally. It's still valid, Helena replied. Never amended, never superseded, still controlling, still binding on both parties. Section 4 specifies that in the event of involuntary termination without documented justification, the employee is entitled to minimum 3 years base compensation. Section 5 specifies immediate vesting of all stock allocations regardless of vesting schedule. Section 6 requires payout of accrued vacation time at current salary rate. Section 7 covers performance incentive payments earned but not yet distributed. Section 8 addresses continuation of health benefits for 18 months. Section 9 specifies that accepting the separation package constitutes full settlement of all employment-related claims. Shall I continue? We terminated her for attitude issues, Diane said, her voice defensive. That's documented justification, isn't it? Is it? Helena asked, raising an eyebrow. Because state employment law requires that justification be specific, objective, and documented with progressive discipline procedures. Attitude issues is vague and subjective. Where are the written warnings? The performance improvement plans? The documented incidents with dates, times, and witnesses? The attempts at correction? The opportunities for improvement? Do you have any of that, Miss Fletcher? Diane hesitated, glancing at Carlos, who shook his head slightly. No, she admitted. This was a business decision. Jordan wanted to reduce headcount in the client relations department. Then it's termination without documented justification, Helena said, which triggers Addendum F, which Isabella accepted by signing the comprehensive release with the language she added. Pemberton tried another approach, leaning forward. The contract says minimum 3 years compensation. We can argue that's also the maximum. No, you can't, Helena replied immediately. Minimum means floor, not ceiling. Means at least 3 years, not at most 3 years. And when you factor in immediate vesting of stock allocations, accrued vacation payout and performance incentive payments, the total compensation owed is significantly higher than just base salary. How much are we discussing? Pemberton asked, his voice tight, controlled. Helena slid a detailed spreadsheet across the table. I'd seen it before, but watching Pemberton's face as he read it was satisfying in a way I hadn't anticipated. 3 years base compensation at $145,000 annually equals $435,000, Helena said, her voice matter-of-fact. Stock allocations granted in 2017, 2019, 2021, and 2023, all vesting immediately per Section 5. Current valuation $162,000. Accrued vacation time, 71 days at current daily rate, $39,800. Performance incentive payment for this year, earned but not yet distributed per Section 7, $48,000. Total $684,800 plus statutory interest at 8% annually from date of termination until paid in full. Every day you delay makes this more expensive. Pemberton's jaw tightened until I thought his teeth might fracture. We're not paying that. That's your prerogative, Helena said calmly. Then we file suit tomorrow for breach of contract. And we add wrongful termination, age discrimination given Jordan Ellis's systematic replacement of employees over 42, and breach of the implied covenant of good faith and fair dealing. We'll be seeking the $684,800 contractual debt, plus punitive damages for the discrimination and bad faith, plus immediate vesting of Isabella's future stock allocations under the theory that terminating her to avoid those allocations is breach of the employment relationship, plus legal fees and costs. Our estimate for jury verdict is somewhere between $1.1 million and $1.8 million, plus the publicity of a trial where your CEO's age discrimination pattern gets examined in open court. Your choice, Mr. Pemberton. The room went silent, completely silent. Diane looked at Pemberton with something approaching horror. Carlos stopped typing. The associates whispered to each other urgently. Pemberton's expression was tight, controlled, but I could see the calculation happening behind his eyes. They'd made catastrophic errors. They knew it, and fighting this would cost more than settling. Finally, Pemberton said, voice carefully neutral, "We need to discuss this internally." "Take your time," Helena said, "but know that state law requires payment of all wages owed within a specific time frame. The separation package qualifies as wages under the contract terms. Every day of delay accrues penalties. I'd recommend settling quickly." "We'll need a week," Pemberton said, gathering his papers. "You have 72 hours, Helena replied. "After that we file suit and this becomes public record. I'm sure Jordan Ellis would love explaining to your clients and investors why he's being sued for age discrimination and contract fraud." Pemberton gathered his papers without another word, his associates scrambling to keep up. Diane and Carlos followed, not making eye contact with anyone. The door closed behind them with a soft click that somehow felt louder than a slam. 4 days later Helena called. "They're offering $520,000, she said. "Final offer. Take it or proceed to litigation." "Not sufficient," I replied immediately. "We established $684,800 as the contractual minimum. Counter with the full amount plus immediate vesting of next 2-year stock allocations. That brings it to $795,000 total." "They'll never agree," Helena said. "Then we file tomorrow," I said. "I'm not compromising. They breached the contract. They owe what they owe. Call them back and tell them $795,000 or we'll see them in court. Make it clear we're prepared to litigate. I have time and resources." "Do they?" She called back 5 hours later. "They've agreed to $684,800 plus immediate vesting of next year's stock allocations," she said, "but they want a broader release covering age discrimination and any future claims." "No," I said firmly. "The release I already signed covers contract and wrongful termination claims. If they want age discrimination specifically waived, they need to pay more." "How much more?" "Another $85,000 and a written admission that my termination was without proper documentation. The admission is key. Once they put that in writing, it's evidence for other employees they've pushed out." Helena laughed, the sound genuine and delighted. "You're enjoying this?" "I am," I admitted. "They tried to discard me like I was worthless. Now they're learning that worthless costs $770,000. Call them back." It took another 3 days of negotiations, but they capitulated. Final settlement, $755,000. Written acknowledgement that my termination was without documented justification as required by my employment agreement. Immediate vesting of all stock allocations including next year's grants. Continuation of health benefits for 18 months. Neutral reference letter for future employment. Agreement that they wouldn't contest my unemployment claim. The check arrived via courier 2 weeks later. $755,000. After taxes, I netted approximately $485,000. But it wasn't really about the money. It was about 17 years of loyalty that meant nothing to Jordan Ellis. It was about watching him systematically push out experienced employees to save on salaries. It was about Diane Fletcher calling me into that office and telling me I had attitude issues after I made her department successful. It was about all the other directors and senior consultants and account executives who were being told they weren't culture fits or needed to make room for fresh perspectives. It was about showing that employees with contracts have power if they understand what they signed. Within 6 weeks of my settlement, 5 other former Titan employees contacted Helena Winters. All over 40, all terminated for vague reasons without documentation. All with employment contracts containing similar separation package clauses they'd negotiated years ago when they were valuable to the company. Helena took all 5 cases. Within 9 months, Titan paid out another $1.3 million in settlements. The pattern was undeniable. Jordan Ellis had been systematically terminating older employees to reduce costs, assuming they'd sign general releases and depart quietly. Most of them had done exactly that. But not me. And once my case proved the pattern, others had leverage. Titan's board started asking uncomfortable questions about why the company was hemorrhaging money in employment settlements, why legal fees were skyrocketing, Why major clients were asking difficult questions about company culture. Jordan tried to blame human resources for not catching the contract provisions, blamed legal for not reviewing documents properly, but the board saw through it. His cost-cutting strategy had cost the company over $2 million in settlements and damaged their reputation badly enough that 4 major clients moved to competitors. 9 months after my termination, Jordan Ellis was quietly asked to resign. The official announcement said he was pursuing other opportunities. The reality was his strategy of pushing out expensive older workers had backfired catastrophically. The board brought in new leadership, someone who actually valued experience, who understood that institutional knowledge has worth, who wouldn't try to replace an executive director making $145,000 with 6 kids fresh out of school making $40,000 each. As for me, I took 5 months off. Actually relaxed for the first time in 17 years. Samuel and I took that trip to New Zealand we'd been postponing for a decade. I read books that had nothing to do with business strategy. I learned to make artisan bread from scratch. Then former clients started calling. They'd heard about my departure from Titan, wanted to know if I was available for consulting work. Within 10 months I had more projects than I could handle. Started my own client relations consulting firm. Hired 4 of the directors Jordan Ellis had fired, all over 40, all incredibly talented, all grateful for the opportunity. First year revenue was $590,000. Second year, $920,000. All without corporate politics or fear of some CEO deciding I was too expensive. The best part wasn't the financial success, though that was satisfying. The best part was running into Diane Fletcher at an industry conference 14 months later. She was still at Titan, looking tired and stressed, like she'd aged 8 years in 14 months. She saw me across the room and tried to avoid eye contact, pretending to be very interested in her phone. I walked over anyway. "Diane," I said pleasantly. "How's everything at Titan?" She looked uncomfortable, shifting her weight from foot to foot. "Fine," she said. "Busy." "I heard Jordan Ellis resigned," I said. "Board thought it was time for a change." She nodded stiffly. "Funny how that works," I said, keeping my tone conversational. "Fire people without proper documentation and eventually it catches up. I hope you learned something from all this. When human resources tells you to just file documents without reading them, maybe read them anyway. Could save the company a lot of money." She walked away without another word, disappearing into the crowd. Helena and I stayed in touch. She refers employment cases to me occasionally, asking me to review contracts and identify leverage points. I've helped 14 people in the past 3 years negotiate better settlements or fight wrongful terminations. Each time the strategy is the same. Document everything. Understand your contracts. Know your rights. When companies try to push you out, make them pay every penny they contractually owe. Most employees don't know what they're entitled to. They assume the general release is the end of the story. But contracts have power. Legal language matters. Small modifications to standard forms can create obligations companies never intended to agree to. If you loved this story about a lawyer's panic call leading to a $755,000 settlement, subscribe now for more workplace justice stories. Hit like. Comment what you would include in your employment contract, and turn on notifications so you never miss when companies learn expensive lessons. Do it now. That phone call from Douglas Pemberton, Titan's general counsel, asking if I'd signed the confidentiality agreement yet. That strain in his voice when he realized what I'd done. That's the sound of a company discovering legal language matters. That employees can be just as strategic as corporate lawyers. That accepting documents without review creates binding obligations. Pemberton thought he was calling to handle a routine termination dispute. Instead, he discovered his company owed $755,000 because they had accepted a modified confidentiality agreement and failed to read a signature section. The silence on his end when I read the language was deafening. Absolutely deafening. The silence of realizing you've made a $750,000 mistake. The silence of knowing your CEO's cost-cutting plan just backfired catastrophically. The silence of understanding that the executive director you thought you quietly pushed out just became the most expensive termination in company history. That silence was worth every penny of the $11,500 I'd paid Helena Winters for legal consultation. Worth every hour reviewing contracts and planning strategy. Worth every moment wondering if they'd catch the modifications before it was too late. They didn't catch it. They accepted my modified confidentiality agreement without review, filed it as my controlling agreement, made it official. Then they handed me a comprehensive release with a signature section I'd specifically crafted to trigger the separation package. They read page 1 where I waived claims. They didn't read page 5, subsection 3, where I accepted $684,800 in contractual compensation. And when their lawyer finally read every word, it was too late. The documents were signed. The obligations were triggered. The trap was sprung. Samuel asks me sometimes if I feel guilty about the money, about costing Titan so much. The answer is no. Not even slightly. They had a contract with me. They violated it by terminating me without documented justification. They paid the price specified in that contract. That's not guilt. That's accountability. They could have documented performance issues properly, could have followed progressive discipline, could have negotiated reasonable separation terms. Instead, they tried to save money by firing me and hoping I'd go quietly. That strategy worked until it didn't. I'm 49 now, running my own firm, making more money than I did at Titan, working with clients who respect experience instead of seeing it as expensive overhead. Every time I review an employment contract for someone, I look for the same provisions I had. Separation package triggers, stock allocation vesting language, specific requirements for documented justification. Then I help them understand exactly what they're entitled to if things go wrong. Because things do go wrong. Companies change. New management comes in. And employees who don't know their contractual rights end up with nothing. That Thursday when Diane called me into her office to terminate me for attitude issues, she thought it would take 10 minutes. Sign the papers, hand over company property, walk out quietly. She never imagined I'd been preparing for 11 weeks. Never thought I'd modified the confidentiality agreement 6 months earlier. Never realized the comprehensive release contained language triggering a $755,000 obligation. That 10-minute meeting cost Titan Strategic Solutions almost $800,000. Cost Jordan Ellis his job. Cost them reputation and clients. All because they assumed employees would always just accept whatever terms they were given. My 17 years at Titan taught me that loyalty without contracts is meaningless. That companies will take advantage if you let them. That knowing your rights is more valuable than any performance review. I don't regret my time there. I learned business, built relationships, developed skills that serve me well now. But I also learned that the moment you become expensive or inconvenient, you're disposable. Unless you're prepared. Unless you've documented everything. Unless you understand employment contracts are negotiable documents that can be modified if you're strategic enough. The phone call from their lawyer. Douglas Pemberton's voice shaking as he asked if I'd signed the confidentiality agreement. That panic when he realized the trap. That's the sweetest sound in the world. Not because I enjoy others' distress. Because it's the sound of justice. The sound of careful preparation paying off. The sound of a company learning that employees aren't powerless. That contracts bind both parties. That legal language matters. That small modifications can create massive obligations. That treating people like disposable resources eventually becomes very, very expensive. Diane handed me termination papers expecting a quick signature. He got exactly that. What she didn't expect was that my signature triggered obligations worth $755,000. That's the beauty of contract law. Both sides are bound by what they sign. If one side doesn't read carefully, they're still bound. Pemberton discovered that at 8:30 on a Thursday evening when he finally read page 5, subsection 3 of the comprehensive release. The language I had added wasn't hidden, wasn't in fine print, wasn't buried in legal jargon. It was right there in the signature section for anyone who bothered to read it. They didn't bother. And that cost them almost $800,000, plus the settlements to other employees, plus Jordan Ellis's job, plus their reputation. All because they thought employees would never be strategic enough to fight back. I proved them wrong. And the silence on that phone call was absolutely perfect.